In this video, we'll discuss regarding question number 26, which is examine the power of the guardian over property of minor under Muslim law. And question number 27 briefly discuss the right of maintenance of a Muslim wife against her husband. Is she entitled to get maintenance after her divorce? After passing her iddat, discussed with help of cases decided by the Supreme Court. So, regarding that, the question number 26, it is falling under guardianship, and as per guardianship, as we discuss regarding the Sunnis, they consider that father and his executor, and regarding the Shias, the father, so also the grandfather, and regarding that father and his executor, so also the grandfather and his executors could be guardians of a minor. And as regarding the very kinds of guardians, as we found natural guardians, testamentary guardians, and guardians by court. So, regarding natural guardian, that we have already discussed in relation to Sunni laws and Shia laws. And regarding testamentary guardian, it is an appointment of guardian that made by both the Sunnis and Shias, and the appointment of mother regarding both and Sunni Shias, they recognize it as two conditions. If she has been appointed as a general executor by the will of the minor's father, or secondly, if the property is solely her. So, in these two conditions, she could be appointed as a guardian of a minor. And regarding that, there are certain formalities to be maintained. That must be the testamentary appointment must be written or may be oral. It may be clear and unambiguous, and the capacity of the tester must be fulfilled under the rules and regulations of Islamic law, and that very person who is making testamentary appointment must be a major and must be a sound mind. And regarding the guardians appointed by court in Mohammedan law, in absence of natural testamentary guardian, the Qazi has the power to appoint any person as guardian of a Muslim minor. So also, now we'll discuss regarding de facto guardian. So that is a self-appointment guardian. And regarding the very powers of natural and testamentary guardians, we found that the Muslim jurist expressed these views that the guardians are appointed for the day-to-day maintenance of the minor, or in imminent danger of being lost or destroyed of the property for the advantage of the minor, and if it fetches double of its value of the property, or for payment of legacies and for upcoming is more than the cost of the property. And also the next guardian has this to some extent the power to grant lease of the minor's property only for the advantage of the minor. So the guardian has also the power to carry on trade or business and invest the minor's property for the very benefit of the minor. Further, the guardian has the power to incur debts for the minor and the power to execute promissory note and all on behalf of the minor and all such for the very benefit of the minor souls of the guardian has the power to partition the property of the minor if there are some other legal heirs, and besides that, the guardian has the power to appoint under Guardianship and Wards Act 1890 enjoys the general powers and obligations of the guardian as provided under section 27 of the Guardians and Wards Act 1890. So also de facto guardian has the power not to sell or alienate the minor's property. So these are the basic rules or provisions as we found both in traditional Mohammedan law relating to natural or testamentary guardianship or guardians appointed by the court. So also as per the very provisions of the Guardians and Wards Act 1890, and as regarding maintenance, the very claim of maintenance must be provided to wife, children, parents, and grandparents. So, all these are the eligible persons who can claim maintenance from the husband, or in case of child, the father, and regarding parents and grandparents from their children and grandchildren, and regarding that maintenance as provided under Islamic law. So a Muslim woman, even during the period of iddat and even after divorce, can claim maintenance, and such as it was decided by the Supreme Court that section 125 of the Criminal Procedure Code 1973 is applicable to a Muslim woman who is divorced, and also it was decided in the most important leading case, Muhammad Khan versus Shabano Begum in 1985 by the Supreme Court, which led the Parliament to enact the Muslim Women's Protection of Rights and Divorce Act 1986. So, regarding that, we must discuss certain views of different schools like the Sunnis and the Shias regarding providing maintenance to an illegitimate child, and it is up to the age of 7, and regarding the Shias, the law, the mother is not responsible to provide maintenance to the children, even she is rich. It is only the grandfather who is bound to maintain the grandchildren if the father is poor. So, also, there are certain other aspects of maintenance regarding the parents and grandparents. And before that, we would like to discuss another important leading case, and that is regarding Siraj versus Roshan, where it was held that even after divorce to the mother, the father cannot deny maintenance to the children by taking plea of the provisions of Muslim Women Protection of Rights on Divorce Act 1986, and under Islam, the sons and daughters having means must provide maintenance to their poor parents. For this, the parents and grandparents must be poor, and their children and grandchildren must have the means. So, according to Sunnis, the mother has preferential right of maintenance than the father. But the Shias, the amount of maintenance must be divided equally between the father and the mother. But all school agrees on the point out of that if separate maintenance cannot be provided, then the parents must be taken to home and be maintained like one of the family. And if the parents have their economic means, then Shias held that the children are not bound to provide maintenance. But to Sunnis, the children are bound in spite the parents having their own independent economic means. So, also a Muslim has an obligation to maintain his poor grandparents, both maternal and paternal. So, this is all regarding the very provision of maintenance as provided under traditional classical Islamic law, so also under the provisions of the Guardians and Wards Act, and also relating to the very decisions of the apex court and all the decisions by other high courts which relates to maintenance. And all these we have already detailedly dealt in our uploaded videos in this channel in respect to guardianship and maintenance.